Can the grand jury force D4vd to testify?
By the time prosecutors subpoena family, they're not fishing, they're closing in.
A teenage girl is dead, the grand jury is active, and the circle is tightening.
So here's the real question. If that circle reaches D4vd himself, can prosecutors force him to testify at the grand jury? And more importantly, would they?
Stay with me, because we're going to examine how this is working. Now let's turn to the story.
Investigators build outward to inward. First, associates. One of the early moves reportedly involved a YouTube influencer known as Neo, described as a close associate. When subpoenaed, he did not comply.
He was arrested in Montana. That tells you something. This is not a casual inquiry. This is compulsion.
Sworn testimony was taken. Stories were locked in. The circle tightened. Then subpoenas reached his mother and brother in Texas. They're fighting the summons, not over travel costs, but because the affidavit supporting the order was heavily redacted. Their argument is simple. If we can't see why we're being called, we can't meaningfully challenge whether we are material witnesses.
That's due process.
But strategically, it signals something else. Prosecutors believe the inner ring knows something. And when prosecutors start pulling family into a grand jury, it's because they believe the center is getting closer.
Now let's examine why prosecutors would ever call the center. Here's where this gets serious. Calling the center into a California grand jury room is not routine. It is strategic. Why would a prosecutor ever do it?
First, to freeze testimony. Grand jury testimony is sworn and recorded. If a target later changes their story at trial, prosecutors can confront them with their prior statements. Second, perjury exposure. If someone lies under oath, that's a separate crime. Third, narrative control. California grand jury proceedings are prosecutor-driven environments. The witness appears alone before the jurors. Their attorney is not in the room during the questioning, though the witness can step outside to consult.
That matters. The prosecutor sets the rhythm. The prosecutor frames the questions. And yes, it's the prosecutor who decides what evidence the grand jury will ever hear. So, strategically, there are reasons to call the center into that room. But there are risks. If the target asserts the fifth for every meaningful question, prosecutors gain little. If they don't need the testimony to indict in the first place, bring him in may signal they are already confident. And that's where the tension lives. Now the defense, the break. If subpoenaed, D4vd must appear. That part is not optional, but appearing is not confessing. Background questions? Perfectly fine, such as, state your name, are you the owner of this vehicle? Did you reside in Los Angeles? These must be answered by the witness in front of the grand jury. Refuse them, a judge can order compliance. Defy the order, contempt, and into jail is a real risk. But then come the questions that matter.
When did you last see her? Did you communicate with her that day? Did you move the vehicle? Who did you call afterwards?
That's where the Fifth Amendment activates. The prosecutors, though, know that. So if he asserts it repeatedly, that is not evidence of guilt, but it is a strategic moment. Now the judge can review privilege. Now the courtroom dynamic becomes visible. The circle tightens, but the Constitution pushes back. Now the cross-examination, the pressure point.
Here's the critical moment. By the time prosecutors consider calling him, they likely already have sworn testimony from associates, friends, family. They likely already know many answers.
Why call him?
Because forcing the center into sworn testimony does one powerful thing. It removes flexibility. If he speaks, his story is frozen. If he lies, perjury risk appears. If he pleads the fifth repeatedly, prosecutors show the grand jury at least they try. But here's the flip side. Grand juries are known for being prosecutor-driven. Targets are rarely called unless prosecutors believe they can indict, regardless of what happens in that room. So if they bring them in, it likely means one of two things. They already believe they can indict, or they believe the act of calling him strengthens their case. And that is where this becomes strategic, not procedural.
Now the law. Under California law, a grand jury has the power to issue subpoenas compelling witnesses to appear and testify. A witness who is subpoenaed must appear.
Failure to appear can result in contempt and even arrest.
However, the Fifth Amendment still applies at a grand jury. A witness may refuse to answer specific questions if the answers could reasonably tend to incriminate them. That privilege is asserted question by question, not as a blanket refusal to testify. Background or non-incriminating questions must be answered under the law. If there's a dispute over whether a question truly risks self-incrimination, a judge, not the prosecutor, ultimately decides.
And importantly, grand jury proceedings are prosecutor-driven. They are not lawless. The power to compel appearance is broad. The power to compel incriminating testimony, however, is limited. That distinction is everything.
Now let's turn to my ruling. Could prosecutors legally force D4vd to testify? Yes, they can force him into that room. They can compel non-incriminating answers. They can challenge improper privilege claims. But here's my ruling. They would only call him if they already believe the circle has tightened enough. Prosecutors do not pull the center into a grand jury room to explode. They do it to lock in a narrative or to expose contradictions when they believe the indictment is near. If they call him and he simply asserts the Fifth to every meaningful question, they gain little unless they were all ready to move forward. So yes, the law allows it, but strategy determines when it happens. And if prosecutors ever subpoena him directly, that wouldn't be the beginning of the case. It would be the signal that the circle has already closed. Investigations tighten. Associates, friends, family, whether this circle reaches the center or whether prosecutors decide that moment serves them, will tell us everything about where this case truly stands. If you want clear legal rulings on the cases everyone is discussing, please subscribe. You're the right place. I'll see you in the next case.